standard language, but not language that is required.
Understood.
And Counsel, you may proceed.
Thank you, Your Honor. Your Honor, I'll try to be brief. I know every time we come before the court, Your Honor has already received a number of different briefs and other documents to explain the genesis of why we are all here. I'm going to start by showing you a picture of the two properties that are actually in dispute. And if you can see on the screen here, the first property that is in dispute is my client's property. And so that's Reed's property. I'll refer to it as Reed's property. The second property that's involved here is the one that's immediately to the left, and that's Mr. Ellis's property. And what's really in dispute is what's going on right in between the two properties. And so if you see that boundary right there, this is where this case is going to take place. What you can see is from the bottom left of the screen, there's a hill. So these homes are built into the hill, and the north is the top of the screen there. And really what happens is the slope of the hill runs down from south to north. And that means all of the water that collects on the hill starts to route its way down, and it flows between these two particular properties. What ultimately necessitated your involvement is that there is a construction project, and you can see on this particular aerial image, you can see the construction project is underway, although as we sit here today, it is near complete, if not complete. And what the issue is with that is going to be threefold, and we'll walk through that and what Your Honor can expect. Let's back up. This is in an HOA. So there's a homeowners association and their CC&Rs that govern the construction, building, and the use of the properties within this particular HOA. And the first one of the articles that we're going to focus on today is 10.1. And in that, what it says is no structure whatsoever other than one private single-family residence together with a private garage for not more than 4 cars. So that's issue number one in this particular lawsuit. The construction project adds this property that's off to the side. This is the new addition, and it adds another 2-car garage. And what the evidence is going to show today, that what that does is it take Mr. Ellis's property from 3-car garage to a 5-car garage in violation of the HOA covenants. The second issue is going to be whether or not the approval and board approval, and more specifically the Architectural Review Committees, the ARCs, approval of this construction project was appropriate. And this is language that is also pulled from the CC&Rs, and it governs the board of directors and how they operate and conduct their business. And the key here is that there's no self-dealing. Self-dealing is defined within these restrictions as occurring when a committee member makes decisions that materially benefit themselves or their business, their employees, their relatives, etc., at the expense of the association. It goes on to say, and if you see those final 2 bullet points there, if somebody seeks preferential treatment for themselves or their relatives, or use association property or services, equipment or business for their own personal gain or benefit. And what I want Your Honor to do is pay attention throughout this case and pay attention to how was this particular construction approved? Who approved it? And when was it approved? Because what you're going to see is that this was an insider sweetheart deal for Mr. Ellis. The testimony as presented today is going to show that Mr. Ellis is not only a member of the community, he doesn't have just a house here, but he's a member of the board of directors and he's the chair of the Architectural Review Committee. Watch how he actually submitted the plans for this construction. Watch what effort went into, if anything, reviewing it, and watch when it was approved. And I will tell you, when it was approved is interesting, given there was no drainage plans, there was no construction plans, there was nothing else for that Architectural Review Committee to review. The third issue that's going to be relevant today, and the key, the reason that we're here on an injunctive relief request, is the drainage. Section 10.28 of the CC&R specifically saying no water shall be drained or discharged from any lot or parcel or building thereon, except in accordance with A, the master drainage study, approved by the appropriate governmental agency and architectural committee, and B, grading and drainage plans approved in accordance with Article 9 and applicable city ordinances. Further, no owner or occupant shall interfere with the drainage established by the grading and drainage plans for the remainder of the property or any other property adjacent to such owner or occupant's lot or parcel. That's going to bring us to Mr. Mario Castro. Mr. Castro is the individual that you saw sitting in the back right of the courtroom today. He's a civil engineer. Mr. Castro was brought in to try and explain, all right, is this construction a concern given the fact that there's relatively small distance between these two particular properties, given the fact that this construction project is taking place?
And we just had someone enter the courtroom. Is that a witness?
Yes.
I'm party.
No, it's Tom McVeigh.
Party.
Okay.
Oh, okay.
He's the association representative.
Okay, very well. Thank you. Welcome.
So Mr. Castro is brought in because when you look at this construction project, you can see where it is. On the image to the left, you can see the red box on where this is going to be. On the image to the right, you can see that, but you can also see the property line. There's about 7 feet between the corner of that construction project and the property boundary. And the question is, all right, if all of the water is flowing through a wash and flowing downhill between those properties, does this cause a problem? And Mr. Castro is going to testify that he went out there and he did a study. He did a hydrology study. He ran the numbers on this. He determined the 3 different basins that flow into this particular area. He'll tell you about the cubic feet per second that flows down the hill through this particular area. He'll tell you what the installation of and construction of this garage does. And what you'll see is, and these are both from his report, which there's no objection, and we'll walk through with him today. But what you'll see is, following the topographical lines and the natural drainage from this property, the construction of this particular garage requires some of the water that would flow more northward to now what I will describe as kink and bend to the right and push out towards my client's property. Does it curve back at the end? It will eventually curve back and flow down and off my client's property into a driveway area there. But you can see, based on these 2 distinctions, that what happens is the water is now diverted. It's no longer flowing south to north. It's now being forced to go east and northeast directly onto my client's property. That's why we came here today, Your Honor. Ultimately, our request at the end of this particular hearing, and understanding that injunctive relief is an interim remedy. It's an extraordinary remedy. It's a provisional remedy. It's not the end of the case. Ultimately, that's something that has to be decided by Your Honor if the parties agree, or by a jury. But here's the 3 requests for relief that we're seeking ultimately at the end of this case. 1, remove the garage entirely. 2, direct the water flow under the garage and the abutting driveway. And that assumes that the garage is permitted and allowed under 10.1 in the first place. But 3rd, and what we're really asking Your Honor to do right now, recognizing that for a TRO, asking somebody to tear down a structure only to potentially have a jury set that aside, at a separate trial downstream and then have to rebuild it, that's very extraordinary. So we're not waiving that claim. We're not waiving that relief later. But what we need from Your Honor right now is just to protect my client in the interim while this case moves forward. And that's the 3rd bullet point request here, which is restore the drainage so that the additional water flow is not directed onto and over my client's property. That's the request we're going to make at the end of the day. Now, how are we going to get there? I'll give you a brief introduction. So Mr. Farrell is going to testify. Mr. Farrell's lived in his property for about 6 years. He'll tell you about how he learned about this construction project. He will tell you about the CC&Rs. He will tell you about his understanding and interpretation of the CC&Rs when he moved into this community. He'll tell you about the 4-car to 5-car conversion. He'll tell you about the drainage issue. He'll tell you about his efforts to try and reach out to the HOA and say, what's going on here? Now he didn't rush to court. His testimony is going to be that first he went over to his neighbor and tried to discuss it. Then he went to the HOA. He'll tell you that he got a Heisman caliber stiff arm at both efforts. He'll tell you that he made a document request to try and figure out what's going on. Can I have the records? This is statutory. You have to provide these documents. He'll tell you that was many months ago, and to this day as we stand here, Your Honor, we haven't received that. When he's done telling you about that, he'll tell you about his concern, about the fact that this increased water flow, velocity and volume of the water that's now redirected towards his property causes concern. Obviously, water flowing across his property is a concern. It doesn't just harm the value of your property, it harms the physical nature and structure of your property, which is why there's an irreparable harm. Following that, Mr. Castro is going to take the stand and he'll put the numbers to what Mr. Farrell says. And he'll tell you about, he went out there, he studied this, he took the pictures, he ran the numbers, he took the measurements. He ran the ADOT report to determine a 10-year or a 100-year storm. What are the potential consequences of this particular construction project? And he'll tell you that there are consequences. He'll tell you about the redirection of the water. He'll tell you about the change in the cubic feet per second that's now being directed towards Mr. Farrell's property. And he'll tell you whether or not that swale, the wash, is sufficient to be able to contain the water in the event such an increase is added to that particular drainage. At the end of today's hearing, we're going to ask for the same thing that was requested in the briefing. And that's ultimately because the garage went up between the filing of the briefing and now. What we need is just to stop further harm and stop the harm to my client's property. We can reserve whether the garage can remain until final resolution of the case in its entirety. But what we will ask is that Your Honor direct that the HOA, and specifically Mr. Ellis, restore the drainage to that which existed before the construction project. That could mean digging that swale or the wash deeper to handle a larger volume of water. It could mean adding additional construction elements to that, all to avoid having additional water flow onto my client's property and cause irreparable harm. Thank you, Your Honor.
Thank you. And counsel, would you like to be heard now or?
Yeah, briefly, Your Honor.
Okay, very well. And please proceed when ready.
Thank you, Your Honor. This case is about what a 1992 recorded covenant means and about whether water moves in a direction plaintiff's own statement and plaintiff's own expert documents contrary. On the covenant, section 10.1 permits on each lot a residence, and then 10.1 provides a list of improvements in addition to that residence. It describes a private garage for not more than 4 cars. It describes 1 gazebo, 1 tennis court, 1 storage facility, and a swimming pool. That's what 10.1 provides. But 10.1 is the section that governs the use of the property. 10.1 doesn't set out to govern the improvements on the property. Those listed improvements are for the basis of the use of the property, and all of the improvements listed in section 10.1 describe detached improvements: a swimming pool, a tennis court, a storage facility, a gazebo. All of those are independent, separate structures, and a private garage of not more than 4 cars. Plaintiff would have you believe that of all of the items set forth in 10.1, the only one that applies to a attached item is the garage. All the others attached to administer detached items. So it doesn't make any sense that 10.1 would talk about 4 improvements that are obviously separate from the property, but list 1 that isn't. So our position and the association's interpretation of 10.1 is the items listed in 10.1 are all items detached. So the garage that's listed in 10.1 is a detached garage of not more than 4 cars. 10.1 does not address garages that are part of the residence and included with the residence, such as the garage that was just built, such as the garage that was previous to the 3-car garage that was previously attached as part of the residence. So the 2 garages are part of the residence. 10.1 doesn't touch them. 10.1 doesn't apply to them. In fact, the declaration has a specific provision regarding garages, section 10.3. And section 10.3 lists no limitation on the number of garages, the number of cars. So the only limitation you find is a limitation on a private garage. Private has to mean something, and it's together with. Plaintiff for that, you believe together with means associated with. In real property world, together with means in addition to. And that's what we're talking here. We're talking a garage in addition to. Now, the defendants built an addition to their residence. The new garage is part of the residence. It's included within that envelope. It isn't construed by 10.1. And like I said, 10.3 is the section specifically governed towards garages. And then another section, 10.17, provides what you do with vehicles. It directs that vehicles shall be kept in garages, carports, residential driveways. There's no caps, but it uses garages in the plural. Whenever garages are used in this declaration, it's always used in the plural. There's no indication that the developer intended these $1, $2, $3, $4, $5 million homes to have 1 garage of up to 4 cars. And that's what the plaintiff wants you to construe 10.1 to say. 10.1 means 1 garage, and the evidence will show that that's just not, there's nothing in the declaration supporting that interpretation. Drainage, 3 things will establish. First, the recorded plat places no drainage easement on the Ellis property. The only drainage easement on the recorded plat is on Farrell's property. So there can't be a violation of an easement when there is no easement over Ellis's property. Second, the city approved grading plans. The city approved the submitted grading plans and the contours. They show water running from the Farrell property towards the Ellis property, not the reverse. Plaintiff's own engineer says so, and you'll see in his own report that the water runs from the Farrell property to the Ellis property, not the other way around. And third, plaintiffs designated a 2002 site plan as the controlling drainage under section 10.28 of the declaration, provides that there's a controlling drainage chart. It doesn't identify it, and it doesn't, there is no controlling chart in the evidence. What plaintiff has done is taken a 2003 request to add a ramada to a property and tried to argue that that is the standard, that is the designated site plan controlling drainage for the area, but it's not. It's a plan for addition of a ramada. That document, in fact, the document is the permit sheet for a detailed ramada. It was drawn 4 years after the Ellis home was built, although it says there was no development on the property at the time. There was. The Ellis home was already built. And it'll show you that the Farrell home, and it was 4 years before the Farrell home was built, 4 years before. So Ellis home was already there, Farrell wasn't there. It can't be a baseline for a property that was raw ground when it was prepared, because if it's a standard, or if it's the if it's the baseline drainage report, it has to consider the Farrell property as well, but it wasn't there at the time, so that can't be the right one. Plaintiff's engineer calculated flows one time for one condition. He never calculated conditions before construction, so you can't compare. You can't say there's more flow today than yesterday if you don't determine what yesterday's was, and we don't have that number. The reef plaintiffs seek, they've said that they're not seeking the destruction of the property now. We believe the proper result here is that the injunction be denied. And if Mr. Farrell wants to pursue through regular civil process, that's fine, but there isn't a basis for injunction here. The evidence will establish that the prejudices go to Mr. Ellis if they go anywhere, that there's no likelihood of success, and that the other elements of injunction have not been met. So we're going to ask that you deny it.
Thank you, counsel.
Thank you.
And counsel, you may proceed.
Plaintiff calls Reed Farrell.
Mr. Farrell, if you could come on up, remain standing when you reach the witness stand, and we'll go ahead and have you sworn.
Please raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Thank you. Feel free to sit down.
Good morning. Will you please state your name for the record?
Reed Farrell.
Is it okay if I call you Reed?
Please do.
Reed, can you tell the judge what you do for a living? Oops, sorry, I shouldn't be.
I guess you'd say I'm a homemaker, trader, stocks and commodities.
And I understand. Is that what you've done your whole life?
Since the 80s.
Okay. And my understanding is you originally came from Chicago?
I still live in Indiana.
Okay.
Yes.
And it's like about half of the people in Arizona. I think the other half are fifth generation Arizonans. I'm going to fast forward to the property that we're talking about today. How long have you lived in that property?
I've had the property since October of 20.
Okay. October of 2020?
2020.
All right. I'm going to show you what's marked as exhibit number 22. Do you recognize, and really I'm just focused on the image. Do you recognize that image?
Yes.
What is it?
It's a desert landscape and 3 homes.
And let's zoom in on those real quick. So I'm going to go ahead and identify the house to the left. Do you recognize that house?
Yes, it's the Ellis house.
Did you say that's the Ellis house?
Yes.
And that's one of the defendants in this case.
Mhm.
The house immediately to the right of it, do you recognize that house?
It's my house.
Okay. And that's the house you live in and have been in for the last 6 years.
Or yes.
All right. My understanding is, and you heard me say it just a little bit ago, but ultimately why we're here is because of a construction project that's happening right in this area, this square. Is that correct?
Yes.
Tell the court briefly how you became aware that there was going to be construction in that location.
I received a text message one day before the porta potty was brought for the construction people, and told that was on, I believe, a Wednesday. I was told that on Monday they're starting construction of a 2-car addition garage.
Who told you that?
Yuri.
Okay, and he's somebody that you knew each other well enough that he was able to text you that?
Yes.
Okay. Did you raise concerns?
Yes.
Did he stop the construction or anything along those lines?
No.
Did you raise your concerns with the HOA and the HOA board?
Yes.
Did they stop construction or otherwise provide you with any documents or any assurances?
No.
Let me ask this. Do you know whether or not Mr. Ellis is on the board of directors for the HOA?
I do.
And is he?
Yes.
Do you know whether he's on the architectural review committee?
Yes.
Do you know what his position is on that committee?
Chairman.
And was he at the time of this construction project and the approval of the construction project?
Yes.
Okay. Let me go ahead and move us to, Your Honor, I'm going to offer Exhibit 22 into evidence.
Any objection?
No objection, Your Honor.
P22 is admitted.
I'm going to show you it's marked as Exhibit number 10. Do you recognize this document?
Yes.
What is it?
Code of conduct, ethics policy.
And this is the ethics policy that's put forth by the board of directors for the HOA?
Yes.
Is this a document you reviewed before you purchased your property?
I believe it was part of a whole packet that was sent to me that I read carefully at the time.
Your Honor, I'm going to offer Exhibit 10 into evidence.
Any objection?
Foundation, Your Honor.
If you could just lay a little more
Certainly.
foundation as to when this.
So you described receiving the whole package of documents before you purchased your property. Describe that package.
It was the CC&Rs and the rules of construction, probably garbage. I mean, it was just a whole, there were a lot of rules. I'd never lived in an association before. And, all sorts of lighting and, the rules that I would have to obey to be part of the community.
And you received this before you purchased your
Well, I mean, it was thereabouts. I mean, I put an offer in, and
My focus is that was in 2020, roughly.
it was.
Who would you receive it from?
I believe it came from management company
And the management company for who?
for the association.
So the association provided you with that package?
Yeah,
And this code of conduct was included in that package?
I believe so.
Okay. Your Honor, move Exhibit 10 into evidence
Any
again.
objection with that additional foundation?
Yeah, foundation, Your Honor. There's no foundation that the board has ever accepted this as a mandatory document. He says he received it, but there's no evidence the board.
I'll overrule the objection, give the exhibit the weight that it's due. P10 is admitted.
So, whether or not they decide they're going to comply with this code of conduct, it's something that was provided to you and you understood was in place at the time you purchased your property.
And on the association website, it lists all these documents that are available to look at.
And is that true as we sit here today?
Yes,
And is the code of conduct that's described here included in the HOA's website?
yes.
I'm going to call out section B and subsection 1 underneath there that says self-dealing. Are you able to see that?
Yes.
And can you read at least the first sentence after self-dealing on there?
Self-dealing occurs when directors or committee members make decisions that materially will benefit themselves or their business, their employees, or their relatives at the expense of the association.
And at the end of that paragraph, if we look down here, it says, accordingly, no director or committee member may, and then the last 2 bullet points say what?
Seek preferential treatment for themselves or their relatives, use association property services, lists, documents, equipment, or business for the gain or benefit of themselves or their relatives, except as provided for all members of the association.
All right, I'm gonna now ask you to take a peek at what's marked as exhibit number 37. Do you recognize this?
Yes.
What is this?
This is an architectural submittal form that is required when any architectural request would be submitted to the management company.
And so I understand it. If, for example, you wanted to do a construction project on your site, you'd pull the form document and you'd fill it out.
And send it to the, yes,
And then the board or the architectural review committee would then review it and give you approval or comments.
well, it would go to the management company first.
Okay. And if we look at this one's specific to, at the very top, we can see at the top, this is for Mr. and Mrs. Ellis. Do you see that?
Yes,
And that property address is the one that's immediately next to your property.
yes.
And then can you tell us what the brief description of the improvement is?
Addition of 2-car garage, attached structure.
Okay. What's the date of this submittal? You can see it on the bottom right.
8/3/25.
So August 3rd, 2025.
Yes,
Okay. If we look at the rest of the submittal, we see the next page is, do you see anything in there other than just the form document?
no,
It's just blank. Correct?
yes,
If we look at the last page, we can see items to include. Do you see that?
yes,
And those items include photo of the home area, design or plan, spec sheets, scheme number, roofs require, all of that, right?
yes,
There's nothing else included in this submittal, at least in Exhibit 37.
no,
Okay. Have you ever seen anything else that was included with this submittal?
no,
Your Honor, move Exhibit 37 into evidence.
Any objection?
No objection, Your Honor.
P37 submitted.
Do you see any reference to grading and drainage or construction plans in this particular exhibit, Exhibit 37?
No.
All it says is addition of 2-car garage, attached structure, correct?
yes,
There's no pictures or anything else to describe what is about to be built. True?
no,
If we look at it, I'm going to show you what's marked as Exhibit 36, and this is going to be small, so I'll try and zoom in on it. But do you recognize what this is?
yes.
What is it?
It's the email exchange of the approval process that was between Yuri and the other members to, well, it says right here, Ellis Family Garage Build, 10 messages.
And we can see you're talking about the Ellis Family Garage Build, so that's the subject line of this chain of emails.
Yes,
And if we can see the individuals on it, do you know who Lonnie Muto is?
I know who he is.
Who?
He's, well, he was the president of the association, but he no longer, I guess he's just on the board of directors.
Okay, so it looks like this email chain is August 3rd, 2025. Was the president then, or was he just on the board?
He was the president.
Okay. We see Tom McVeigh. Do you know who that is?
I'm familiar with his name. I've never met him.
Okay. Do you know if he's on the board?
Yes,
And is he?
yes.
Okay. What about Brenda? Do you know who Brenda is?
I've never met her, but I understand she's on the board as well.
And then we see the last person here is Mr. Ellis. Do you see that?
Yes,
And he's the one who sent it, and he also copied himself, correct?
yes,
Okay, as we go down this, we can see that the very first email that was sent by Mr. Ellis specifically says, please see attached agreement that I am planning to sign, but need architectural committee approval prior to me signing it. Would really appreciate a speedy review. It will be an attached garage instead of a detached structure, as this allows us to make it work with setbacks. Everything else is pending city approval. Do you see that?
yes,
And so you understand he's talking about the actual garage structure that's at issue in this case, right?
yes.
If we look at the attachments.
Your Honor, I do want to object to foundation to some of these questions. He's asking questions regarding, people's, what they were intending in the email and what they're talking about. He has no foundation to discuss that.
Let me back up and start by just moving Exhibit 36 into evidence.
Go ahead. First of all, any objection to 36 being admitted.
No objection to the omission, but objection to where it can go with it.
All right, the court will admit P36, and I'll consider questions that question by question as counsel proceeds.
Thank you, Your Honor.